Hi, everyone, and welcome to Multi-Jurisdictional Employers Part 1, Independent Contractors versus Employees, Classifications under Federal and State Laws. This kicks off PilieroMazza's multi-part series on the best questions we get from multi-jurisdictional employers, which is one of the things that we dabble in quite a bit over here. Next slide. My name is Nichola Atallah. I've been at PilieroMazza for about 15 years, give or take. Lose count after a while, but our practice specializes in both assisting government contractors and assisting government contractors and commercial businesses with multi-jurisdictional issues. So how to best help you all manage your risk as you employ people in multiple jurisdictions. And I'm here with Georgi. Next slide. Georgi, fun fact about yourself.
I'm from Chicago, youngest of 4 siblings. That's not very fun, but.
And Georgi's been with us a couple of years now and has really been pivotal in working through some of these issues. So very excited that she's here with us today talking about independent contractors. This webinar does qualify for HRCI credit. We will give that code at the end of today. So that's usually one of the first questions out of the box. You can also, if you need a copy of the slides, I think we provide the recording. I can correct that. But if you need any specific content out of today's presentation, just please shoot us an email, let us know. We're happy to try to get you what you need. PilieroMazza is a business law firm. We serve clients throughout the United States, whether you are, needing help with labor and employment, like we're talking about today, corporate, dispute resolution, and government contracting. So we do a wide variety of legal assistance, support, and compliance for our clients, and happy that you are all able to join us today. Next slide, please. All right, so what are we doing today? We are going to really dive into managing risk for independent contractors across the federal and state landscape. So my disclaimer about today is we are not going to specifically dive into every state and every state test, and we're going to explain why. That would take us multiple hours and probably multiple days. But what we try to do is help clients manage their risk over multiple jurisdictions. So when we're talking to clients about this stuff, the first thing I'm saying is how many of these folks do you have and how many states? Are they all doing the same thing? Are they doing different things? And there's an analysis that we work through to try to help clients come up with the best business decision based on how much risk you want to take on as an organization. Because this particular topic is not a black and white. It is a risk proposition, right? There is no one out there that's going to say 100% this is always IC, always employee. It really depends on where you are, what you're doing in that state, and what that particular position is positioned to do within your organization. So we're really going to talk about why this matters in your organization, why you should be paying attention. We're going to give you some guidance on how to classify individuals as independent contractors. I could spend another full day talking about the Fair Labor Standards Act and why that is important, but today we're focusing on independent contractors. And then we're going to talk about the different tests from a broad brush. Like there are some commonalities that both the federal and state agencies use in order to determine independent contractors. So we're going to kind of walk through that. That's what we're doing today. Next slide. So why is this important? Well, in the United States system, we assume that everyone's an employee unless you can find an exemption for it, right? And we assume that everyone's an hourly employee unless we can find an exemption to it under the Fair Labor Standards Act or because they are truly independent contractors. So when I'm talking to HR folks or COOs, I say never start from the proposition that someone should be an independent contractor or should be whatever. Start from the proposition that they should be employees and that they should be paid hourly, right? That's the presumption. And then we need to walk out of that by justifying why someone can be an independent contractor. And it's important in our system because independent contractors cannot avail themselves of certain laws and investigations, right? So if you're an independent contractor, you don't get unemployment. You don't, your employer isn't paying your taxes into your state. You're doing that yourself. You're not going to be able to file a discrimination or harassment complaint, right? So really how this comes up for organizations is when those people, as they will inevitably do, especially in the environment right now, right? They're going to get laid off, or you can't keep them anymore, right? Because you can't have that service anymore. And then they're going to go apply for unemployment because they don't have a safety net. And then all of a sudden you get a UI investigation, or they really think they've been discriminated against by your client or someone within your organization. They file an EEOC claim, or they think they should get overtime payments. And so they complain to Wage and Hour. That's how these typically come up. And when they do come up, it can balloon very quickly because, for example, Department of Labor is not going to investigate one person. They're going to investigate your entire workforce, right? And then they might have a memorandum of understanding with the Department of Taxation. The Department of Taxation then gets involved, and then you have taxation issues. So that's how this kind of comes up, and it can be a significant financial impact. It also comes up because there are a lot of folks out there that have been independent contractors and have positioned their lives around being independent contractors for many, many years. And so when you are, going into a situation where someone says, well, I've always been an IC, I want to be an IC, clients call me about this stuff. I'm like, it's not their decision. Like, you can certainly take into consideration that you might not be able to get them on your ship unless you make them an independent contractor. But at the end of the day, the risk is going to be a corporate risk. We can't pass that risk off. Even the best laid independent contractor agreement cannot shift that, that regulatory risk from you to the employee. It's very difficult to do. So again, it can get very expensive very fast. We have federal and state considerations here. So we're really looking at the multitude of ways this can come up and how to manage that given the number of tests that we have. Next slide. So this is just kind of an overview. We're going to then dive into these tests, right? So the DOL uses like an economics reality test, which we're going to talk about in a few minutes here in more depth, where the IRS uses more of a control test. Then you've got these common law, we call a Darden test, that many states use and federal entities use. And then states then can use other tests like the ABC test, the economic reality test, the common law test. But as you will see today, I think as we go through these tests, what I want you to take away is that there are common themes throughout these tests. You might run into a quirky situation or two that's kind of an outlier, but if you generally are looking at the common factors under each of these tests, you're going to see they're not that different. The biggest one is really the ABC test, which we'll talk about later on the state side. That is kind of the biggest, I guess, obstacle in many cases to classifying someone as an independent contractor. But otherwise, many of these tests have very similar themes. And I highly recommend, talk about this at the end of the day too, but as you're going through, really think about what kind of checklist you might want to put together when you're analyzing whether someone should be an independent contractor. We have kind of one that, you could start from. Shoot us an email, we can send it to you. It's really a starting place based on how you want your standard operating procedures to go, but it's something to think about as you go through today. I would recommend this for classifying people as exempt, non-exempt employees too. You really should have a mechanism within your organization to think through these different issues that we're going to talk about today, because otherwise I think what normally happens is your project manager or a supervisor, I found this great resource, he's going to be amazing, or she's got this great skill set. Let's just bring her on as an independent contractor. Everybody seems fine with it. You ride off into the sunset until the Department of Labor comes knocking at your door, or the IRS comes knocking at your door. It's really helpful to have that rationale and to look at that over time, because folks don't, sometimes folks start off as ICs And then over time, they're doing more and more and more and more work for you, and it's harder to justify over time. So really putting those standard operating procedures as to how we're going to classify and evaluate risk will be important. Next slide.
Okay, so starting with the Department of Labor, the test that they use here is called the Economic Reality Test, as Nicole mentioned. The reason the FLSA is implicated through the DOL is because the DOL enforces the FLSA. And because of that, the DOL focuses on classification to determine who should receive minimum wage or overtime pay requirements. And that is because employees are going to receive minimum wage and overtime pay, whereas those same benefits aren't available to independent contractors. So the DOL uses this test to determine whether the worker is economically dependent on the employer or if they are in business for themselves. And we've seen in the past that the DOL's test kind of fluctuates between administrations. So for example, in the previous Trump administration, he tried to simplify the test that was used a little bit, and the focus there was on 2 core factors. But now, as of last year, 2024, a final rule was published by the DOL, and that enforces the current version of the economic reality test, which has 6 factors, which we will go through on the next slide. Okay, so first I want to note that there are 6 factors to this test, but each factor should be analyzed together with all the other factors, so no one single factor is the most important or carries the most weight. So you're really going to want to take a holistic approach when you look through each of these factors. So I'll go through each of them one by one. The first one is opportunity for profit or loss depending on managerial skill. So some things to consider with that factor are, does the worker negotiate their own pay? Are they hiring their own workers to complete the work for the employer? Are they engaging in other efforts to expand business or secure more work for themselves? And if the answer to all of those questions is yes, this factor will lean much more in favor of the worker being an independent contractor versus an employee. The second factor here is investments by the worker and the employer. So some things to consider here are the entrepreneurial efforts that the individual is putting into the work. Are they trying to support a growing business? Are they trying to increase the number of clients that they have? Are they trying to reduce costs and increase sales? And again, if the answers to those questions are yes, much more likely to be an independent contractor versus an employee. The third factor here, which is probably the easiest one, is the permanence of the work relationship. So if the individual has a sporadic relationship with the company or is brought on for a specific period of time for a certain project, for example, and they have a fixed end date, much more likely to be an independent contractor. Whereas if they have an ongoing continuous relationship with the employer with no fixed end date, much more likely to be an employee. But note that short-term jobs may be due to the seasonal or temporary nature of the work completed by the employer. So that does not automatically mean that because an individual was brought on for a few months, that does not automatically mean they are an independent contractor.
Yeah, and the frustrating thing about this test, and I think part of what the Trump administration was trying to do in the last administration. Again, we haven't seen any changes yet. We may see changes soon to how the DOL is going to approach this. Although the secretary is somewhat labor friendly, so it's hard to figure out where they're going to go with this. But it really is a multi-factor test, and any investigator can kind of glob on to any one particular thing. So I've had cases in the past where the DOL investigator really focused on the fact that they had a government issued computer. It's like, well, of course, everyone that works on this contract, they have to have a government issued computer. You know, our company is a contractor to the government and we don't have our own computers, right? We use government computers. So you can kind of work that. But outside of that, you might want to have employees get their own equipment unless you have a specific reason to. things like if the person doesn't do the work well, is there a clause in the contract that says you have to fix the work at your own cost, right? So let's just say you decide to have a per hour compensation method. Well, there's not a lot of opportunity for profit and loss there unless because it's not about them being efficient. It's not about them increasing the productivity or anything. They have an hourly rate. That doesn't mean they're not an independent contractor. It just means where's that other opportunity for profit and loss? And one way to do that is to say, hey, if you have a non-conforming service, you might have to re-perform the service to our satisfaction without remuneration for that, right? The other one I think some folks lean on probably too heavily is this idea of the permanence of the work relationship, because you can have part-time temporary employees. They exist, right? So you wouldn't want a situation where the only thing you've got going for you is the permanence of the work relationship, right? That, well, I just needed somebody for a couple of months over the summer. I just really needed that summer help or that seasonal help. You can have seasonal help that is not IC work. It's really employee work. So you want that permanence of the relationship, to be more temporal, or I get to pick my shifts, or I get to decide what work I want to take. I can turn down work. I really get to control how I perform the work. You also want to take a look at, are they sitting right next to an employee that's doing exactly the same thing day in and day out? Probably harder to justify, right? Are they working for you 40 hours a week every week for 10 years? At some point in time, they're probably too economically dependent. So you really have to think about who in your organization is going to make the call when you have some things going for you and some things not going for you. And what's your threshold for risk? Because there isn't really one or two things that are really important to all of the Department of Labor. You get different investigators who kind of get hung up on different things, and the Department of Labor is particularly inclined to find, again, employees, right? We're starting from the proposition that everyone should be an employee and working backwards from there. Anything else on this one?
Yeah. Let's talk through the last three factors here really quick. So we have the nature and degree of control. So if the employer exercises a great amount of control over the individual, like setting their schedule, they're reviewing their performance and evaluating, like giving a performance review is often indicative that the individual is more likely to be an employee than an independent contractor. Can they discipline the individual? Do they supervise and kind of oversee the day-to-day of the individual's work? And the next one is whether the work performed is integral to the employer's business. So the question here really is the work critical or necessary to the employer at the heart of their business? Do you have an example of that?
Yeah. So, if you are hiring an independent contractor to do something that's kind of outside the normal course and scope of the day-to-day work, like if you are a janitorial business and all of the folks working for you are independent contractors, probably a red flag, because the janitorial work in and of itself is integral to the work that you perform, right? You kind of can't maneuver around it. There are kind of, again, exceptions to this, right? I think about industries like courier services, court reporters, medical records clerks, where it's pretty common to have independent contractors doing that work. That work is integral to the employer's business, but they have all of the other factors going for them, right? So again, it's a factor you might have to overcome if the work is really, a core part of the business that you do.
And then lastly, for skill and initiative, some things to consider on this one are, does the worker complete a specialized skill that might be different than what employees of the company are completing? Or does the individual make independent decisions regarding their work and sort of take all of the initiative over their tasks? And lastly, again, I just want to say it's a totality of the circumstances analysis. So no one factor is the most important. They really need to be considered together. Next slide, please. So the next two slides, we just list some characteristics that are indicative of either being an independent contractor or an employee. So here we have a few that are leaning towards the individual being classified as an independent contractor. But of course, again, consider it with all of the other factors too. So some examples are running one's own business, which kind of goes with working with multiple clients. So the company is not the only company that they are working with. The temporary relationship, which we already touched on in more detail, when they really set their own schedule and decide when and especially how they're going to complete the work for the company. And then, yeah, providing their own materials, tools, or equipment. That is a big one. Nicole mentioned the government computer, so that's not definitive, but that's an example.
And you kind of have to think about things like, you know, I've had clients over the years say, well, I just make everybody who's an IC form an LLC, and then we're good to go, right? Well, it can be a little bit form over substance. It helps, right? It could help. They went to the trouble to have their own corporate entity. They're running a corporate entity. I know there's some organizations that get really hung up on, and by org, I mean like government agencies that are like, do they have a business card? Do they have a website? Are they? They get really hung up on those details because these multi-factors are difficult for them to go through too. So you kind of find these bright line, you know, how can you show that you're running your own business if you don't have a business card or you don't have a website, which again, form over substance, but you want to have that together with other of these factors. Next slide.
And here are a few examples of factors that might lean towards employee status. So opposed to the previous slide, an employee would be much more likely to only work for the employer and use the employer's materials, tools, and equipment. The employer will often set their work schedule and their specific work assignment, the specific tasks that they need to complete on a day-to-day basis. A continuing relationship with no set end date. And again, the employer will be more likely to discipline and supervise and just oversee the relationship much more closely than they would with an independent contractor.
And just to reiterate, because I know I'm going to get some people that say, well, we pay all of our ICs by the hour, right? These are multi-factor tests. So again, that hourly payment goes to that concept of profit and loss and you can mitigate that by doing some other things like making them responsible for a certain quality of work product. But it is true that if you have somebody that is working 9 to 5, Monday through Friday at your office, they've done it for the last 5 years, they're working alongside your employees, they're using your computer, they just happen to have some like specialized skill, probably going to be an employee, right? You've got clear economic dependency there. Next slide. All right, let's talk about the IRS.
So as we addressed at the beginning, many agencies use many different tests. So the next test we're going to be talking about is called the control test. And the IRS, while a lot of these factors are pretty similar to the ones we've already discussed, the IRS kind of places the focus of their test on more of the control element. So how much control the employer has over the individual. And this is important for tax purposes, obviously. So there's three main categories that the test covers, and those are behavioral control, financial control, and relationship of the parties. And within those three categories, there's many more factors, but the test is simplified when you consider those three categories separately. Next slide, please. So the first category we will talk about is behavioral control. So when you think about this, you can think about the type of instructions that the employer gives to the individual. So is the individual told when and where to do the work, what tools to use, who to work with, Again, this is all pretty repetitive from the previous test, but another factor here would be how much instruction the company gives to the individual. Are they, again, supervising on a day-to-day basis? Are they controlling most of the work that the individual does? The evaluation system, again, is the individual provided with a performance review, discipline, and then training? Does the employer provide the individual with training? That is a typo. But when the individual is brought on, is the employer responsible for providing them with training on their day-to-day tasks, or does the individual bring their own skills that the employer does not need to show them the ins and outs of? And does the individual use their own methods to complete the job?
I mean, I suppose if you're running a gym, and
Then I guess it would be relevant, yes.
it would be relevant. So, yeah, and you can start to see the themes, which is why I think it's helpful to kind of lay out these tests, because you start to see the themes running through both. They're a little different. The emphasis is different, but you start to see the themes. Next slide.
So another big category here would be financial control. So does the individual have a significant investment in the equipment used? Do they own the equipment themselves? Or does the company provide them with a laptop, for example? Unreimbursed expenses. If an individual is taking on a lot of the expense of completing the work and not receiving an expense reimbursement, or not having access to an expense report, for example, much more likely to be an independent contractor. Again, opportunity for profit or loss. Do they engage in their own efforts to expand the business? Are they running their own business? Are they free to seek out other business opportunities? Much more likely to be an independent contractor. And then again, method of payment. So are they hired for a specific period of time and only working on that specific assignment, or on that specific project? Or is it a regular wage, salary, hourly, etc.? Next slide, please. And then the last category here is relationship of the parties. And while we've already touched on permanency of the relationship, we won't talk too much more about that. But one important category here would be employee benefits. Employees are much more likely, or generally are the only ones who are going to receive benefits from the company, such as PTO, sick leave, retirement plan, etc. Do they have a written contract, or are they an employee at will? And then again, that same key activity of the business, is the individual's work really central to the core of the employer's business?
Next slide. Yeah, this stuff can get really expensive. So I think we kind of alluded to it in DOL. In DOL land, the risk is that you have somebody that worked a lot of overtime, a lot of time over 40 hours a week, and they were improperly classified. And so you have to pay that time and a half rate. And then depending on how you've paid folks, that can get kind of expensive. Sometimes the risk on the DOL side is low if they're not really running into much overtime. The risk can be relatively low, and could it just include a determination that they should be employees. But DOL also has MOUs with other organizations and agencies like the IRS, where they can kind of report you to the IRS. And the IRS is where it gets expensive, because the IRS, not only do you have to pay the employment taxes into the IRS that you didn't pay, even though the employee was supposed to pay them too. It's like a correction, a tax correction, right? You can also be subject to penalties for failure to pay those taxes. So it can get very expensive very quickly. The focus, even though you saw a lot of overlap in the tests, the focus of the test is different. So what DOL is really going to focus on is how economically dependent the person is on you, where the IRS is going to focus on how much control you have over their work, the opportunity for profit and loss. So, you could be talking to one DOL investigator, one IRS investigator, and they are talking to you about completely different factors and focus. So it's important to take that into account. Next slide. There are other agencies that have other tests, right? So the big ones we always think about are IRS and DOL, and that's why we went into those with some specificity. But there are also tests that the EEOC uses, and that's called the common law Darden test. Every agency kind of has its own tests. Even the Small Business Administration has its own IC test for when you can count someone as a subcontractor, because in government contracting land, independent contractors are considered subcontractors. So it can be important for things like limitations on subcontracting, how much of the work you can give out if you're in a specific business classification. So again, you have to pay attention to the fact that all of these different agencies have different tests. The Darden test really focuses on the employer's right to control the, quote, manner and means by which the work is performed. That's kind of that idea of control seeping back in, right? So they're looking at things like the skills required to do the job, the source of the supplies and tools, the work location. Are they working at the same place as all of your other employees? How long they've been working there? And again, the EEOC uses that test to determine whether someone can avail themselves of the non-discrimination provisions in Title VII, the ADA, the ADEA, and ERISA. So that's also at DOL under ERISA, but they're using a separate test, like a different part of the DOL using a different test with similar factors. Next slide. So I always say you take federal law and state law and you read them together. So there's no real preemption because the federal DOL, the federal IRS, the federal EEOC have one set of objectives and things that they're enforcing, and state agencies have similar objectives, but on the state level. So in employment land, we read everything together and we take the most restrictive of those things, and that's what we have to apply. And that is my general rule of thumb for almost every webinar or legal issue in employment law. The most restrictive of these things applies. So in addition to state DOLs, state departments of labors or industrial relations or whatever the state calls it, and the state taxation authority, the state version of the IRS, you also have a number of different state agencies that have independent contractor classification rules. You've got unemployment insurance, workers' compensation. You might have special statutes for construction companies and classifying folks. And these classification methods can differ from state to state. Like, how frustrating, right? So you have different tests at the federal level, different tests at the state level, and different tests at each agency within the federal government and at state levels, right? Common themes, but they can have very different impacts. I was talking to a client actually earlier today that received an unemployment claim, and all that investigator cares about is whether there's a business card and a website. They don't care about all of the other things that we've talked about, because their goal at the investigation stage is to figure out a way to make that person an employee so they can get their unemployment insurance payments, right? They're trying to keep that program solvent. That's their job. But if we're talking about a few $100,000 or a few $100 or a few $1,000s, do we really want to litigate with unemployment? It's not often about whether you can win. It's about whether or not, what its overall impact is, right? Certain states have more restrictive tests, like California and Massachusetts, and we'll talk about this test, but they have a very restrictive view of independent contractors, and they make it very difficult to make an individual an independent contractor. I talked about kind of there's this, Maryland as well has very specific regulations with respect to the construction industry and presumes an employer-employee relationship. So you really have to look at what industry you're in and what states folks are in to determine how restrictive that test is. And we did have a question that I try to kind of take them as we go if I can. For ICs working remotely, does the state law where the person resides in apply, or where the business is located? Not just for this test, but for almost every test in employment law, you are looking where the person is working. And so you should presume that the long arm statute, that's a very legally, before I went to law school, I had no idea what a long arm statute was. So basically it allows the state to exercise jurisdiction over your business. But the minute you hire someone in a state and they work within that state, most of the employment laws of that state attach. So if you have you're headquartered in Virginia, but you have a completely remote workforce, you should be thoughtful about what states you don't want to hire people in. And a good example of that is California. So California uses a very restrictive test called the ABC test, which we'll talk about more in depth in a minute here. It makes it very difficult to have ICs in California. Let's just say you have 5 or 6 people working in the state of California as independent contractors. You make one of them really mad. The client doesn't like them. The relationship goes south. Name your parade of horribles with this person. This person's a complete nightmare. They complain about everything. They go talk to a plaintiff's lawyer, and that plaintiff's lawyer says, aha, in California, if you're a non-exempt employee, you get meal and rest breaks. You have to have certain things on your wage statements, and there are penalties for all of those things. And by the way, because you have a group of folks in California or across the United States, depending on the allegation, we have a great class action. And class action lawsuits are really, really expensive, particularly in California. And the allegations there are that these people really should have been employees, not independent contractors. There are all these penalties that have attached for failure to pay, meal and rest breaks and all of that jazz, or overtime payments, or whatever the case might be. And because it's so expensive to litigate those lawsuits, most of the time they settle, often for hundreds and thousands of dollars, if not millions of dollars. And we have had a number of these cases. There are a couple of common law firms that we see come across the reader board. So this can get very expensive very quickly if you don't understand what it means to hire an independent contractor in a different state. So I tell clients all the time, there is no law against saying, I don't want to do business in the state of Massachusetts or California or New York or whatever, Colorado, Hawaii. You could make a business decision that it's just not worth it to take on that degree of risk, but you should assume that you are availing yourself, subjecting yourself to the state where you hire people, whether it's an independent contractor or an employee. Next slide. All right, so here's an overview of the test. The ABC test is the one I was talking about earlier. It's used by California, New Jersey, Hawaii. There are a couple of states that do kind of an ABC light. I think Massachusetts is in that bucket, DC's in that bucket. So there are a number of states that employ this test, and it truly does presume that workers are employees, and it creates a number of hurdles, which we'll talk about in a minute. There's also a very similar economic realities test, which we kind of talked about earlier under the Department of Labor. It's very similar to the DOL's economic reality test. DC wage payment and collection law uses economic realities. And then there are a number of common law tests that also use a lot of the factors we talked about today already. Next slide.
So the test we just discussed is the ABC test used by California and a few other states, and it is extremely restrictive. And unlike the control test and the economic reality test, which was a totality of the circumstances, so you don't consider any one specific factor over another, for this test, you need to prove all of these factors in order for the individual to be deemed an independent contractor. So the first element here is absence of control. So is the individual free from the employer's direction and control? And to think about that question, you can think back to some of the factors we discussed previously. Does the employer supervise the individual? Are they providing their work schedule, work assignment, etc.? The second factor would be customarily engaged. So is the individual customarily engaged in an independently established trade, occupation, profession, or business? We'll discuss this a little more on the next slide. And then the third factor is business of the potential employer. So if the work is either performed outside the usual course of business for the employer, or is the work performed outside of the employer's place of business? So you would have to prove yes to one of those questions for the individual to be deemed an independent contractor.
Number 3 is what gets a lot of clients. Like you can kind of, number 2 sometimes gets people, but it's really number 3 in my experience that is really difficult. Like if, let's just say you are in the business of making widgets and you hire an independent contractor who is helping you reorganize your business processes for making widgets, it's going to be hard to show, you know, we might have an argument that, well, my usual course of business isn't my standard operating procedure. It's like, this is a specialized consultant that helps with business processes. The other side of that is, yeah, but they're helping you figure out how to make your widgets, and you're in the widget making business. So that is one of the bigger obstacles. If you're a government contractor, your business is government contracting. That's the broader part of it. So arguably, everything you do under that contract that's in the statement of work, maybe not necessarily your marketing or your finance or something like that, but everything that's in that scope is arguably in your business model. And so it's, you know, we can deviate from that a little bit in making distinguishing characteristics. Like, well, my business is usually, you know, driving straight ahead, and this one component of the statement of work says you have to turn right for 5 minutes, but it's really difficult to show. Next slide.
So this slide just lists a little more details on each of those 3 factors. So the first one, control. An individual can be deemed an employee even if the company does not control the exact manner. So again, this test is the most restrictive. So they don't really need to show that the employer is controlling every single aspect, but are they controlling the schedule at all, the overall tasks that are given to the individual? If the answer is yes to that, they're going to be an employee rather than an independent contractor, most likely under these more restrictive states. The second one, independent business. So we've mentioned this before, but does the individual have an LLC set up, a website for their own business? Do they have their own business cards? Those lean towards yes, the individual is going to be an independent contractor, but only under, again, the specific factor. You need to prove all 3 of these. And then Nicole just talked a little bit more about the third factor being outside the employer's usual course of business. So courts may think about the following questions: whether the worker's services are necessary. And we touched on this with the other tests. It's similar to the if the individual's work is at the core of the business. And then whether the employer continuously uses the individual's services. So if the individual keeps returning back to work with the employer.
Control is also an interesting one because I get a lot of questions about control. It's like, well, yes, these people go out and they do inspections of grocery stores, or, you know, they're really operating independently. There's some guidelines that they have to follow, some industry guidelines, some requirements in the contract that they do have to follow. But largely, they're deciding when and where they, you know, when they go, how they approach the site, how efficient they are. They're paid by the trip. But at the end of the day, they submit a report to some sort of program manager or officer that's doing quality check reviews. That is not necessarily control, as long as it really truly is just like quality oversight, and is not, you know, we're telling you when to come to work, we're telling you exactly how to do it, we're training you, we're doing everything. That's, you call me every time you leave that grocery store after you've inspected whatever you need to inspect, that starts looking more like control. So you can have oversight. It doesn't mean it's completely without oversight. Obviously, a business has an investment in making sure that these folks are doing and delivering what they said they would deliver, but you want to make sure it's not supervision. Next slide. So how do we reconcile all of this? So the number one thing I get is like, clients, their eyes start glazing over and they're like, how do I manage this, Nicole? And a lot of times what we tell folks is like, this is a business risk proposition. You might have folks that, that are employees in most states, but you're not willing to take the risk in California, New York, New Jersey, because the risk is just too high. And so you make those people employees in those states, and there's a justifiable reason why they might be employees in those states. And you can make the argument, we believe that we meet the federal requirements, but we're concerned about the state requirements, so we have employees in those states. You could decide not to go into certain states and hire people in certain states. You could decide that you're going to be largely compliant and understand that there is a risk, that there is a gray area, and you may have to deal with one of these agencies, the state IRS, Maryland Unemployment, whoever it might be, and you might get lucky and not have an audit or investigation for 10, 15 years. In other cases, it can get very expensive. So I generally say, like, you have to first kind of decide, are we very risk adverse as an entity? And if you are really risk adverse, you should have very few independent contractors. You should mostly employ people, make them exempt or non-exempt under the Fair Labor Standards Act. That proposition is going to be much less risky. Doesn't mean you can't have an occasional independent contractor, but those are going to be outliers to you, right? They're going to be specialized skills. That person is incorporated. Maybe we just needed some help with some marketing or some HR consulting, and these people are independent contractors. Those things are kind of outliers. Your risk is relatively low. They're not working full time. We don't have overtime risk. We know they have multiple clients. Risk is very low. If you are in other industries where you rely heavily on independent contractors, or the people performing work in that industry are very accustomed to being independent contractors, you may need to take on some additional risk there and try to say, like, okay, we need to make sure we have a very good independent contractor agreement. If we're anywhere, if we have a cross kind of a certain number of independent contractors, or we are in riskier states, maybe we want to have an arbitration agreement and class action waiver to mitigate the risk of a class action. Maybe we want to make sure that we are not paying for the laptops. We're not paying for the cell phones. Maybe we want to make sure that we're not telling people how to dress, right? That when you hire independent contractors, you can assume that they are going to conduct themselves professionally because they're independent contractors. And if they're not, like, you shouldn't have to tell them how to dress, right? So again, different companies are going to have different risk propositions. What I usually recommend is that clients, gather the list of all the states they're in, make some decisions up front about states that they are not going to hire folks in unless they get approval from the C-suite, right? Whoever that is within the C-suite. And that there are factors and a process that we go through in determining whether or not we're going to hire independent contractors. In some industries, it's a lot easier to justify than in other industries. It just depends on how the work is organized, right? It's an overall cost-benefit risk analysis, which is incredibly frustrating to clients. When you say maybe, gray area, spectrum of risk, like that's like lawyer 101, clients hate it. But at the end of the day, it's not me that has to write the check to the IRS, right? So we can certainly walk you through the tests in the states, what states are more risky. We can help you really hone in on comfort level on those checklists and standard operating procedures, how to mitigate against risk. We can give you our opinion on whether or not you meet the requirements for independent contractors in a certain state. But at the end of the day, you can't plan for every fact that's going to occur in the future, right? So, you start off 4 years ago with somebody who's a clear independent contractor. They really work with your organization very well. You're paying them pretty well, right? Under the independent contractor agreement. So they start doing more and more work for you. And at some point in time, someone has to have a gut check in there to say, you know what? I don't really think you're an independent contractor anymore. You're really doing most of your work for us. You're really relying on our systems. You're really integrated into our organization at this point. But you've got to have those standard operating procedures that give someone a chance to look around and say, do we have anyone that's transitioned really to more of an employee, right? And if you don't have those benchmarks built into your system, you're gonna kind of miss it, right? At some point. So even if I always try to emphasize that that a person that wants to be an independent contractor, I think I said this earlier too, but just because they want to be an independent contractor is not dispositive. So you can't have them sign a statement that says, no, I really want to be an independent contractor. It's cool. That risk is on you as the company, and you really have to make sure that you adhere to that. So we do have another question. Somebody said, I have my own consulting business and customers always want to use their own MSA. It seems to me a bit like it would be better to reflect my own business status to use my MSA. Does that make sense? I think that does make sense, that contractors would come to the table with their own contract. But if you look at it I don't think it matters as much who provides the first draft, but more whether it was fairly negotiated, right? So if the customer or the larger business wants to use its MSA and will not negotiate, will not change a term, and the terms, seem a little bit funky to you, then it does seem like they're taking on a little bit more risk in doing that. But I've never seen an agency say, well, who drafted the contract was dispositive. And from each business's perspective, whether you are the independent contractor or you are the other business, everybody wants to use their own first because they've had those terms vetted, maybe by a lawyer, maybe internally, right? So everybody wants to start from their own. But I don't think it's unusual to have an independent contractor say, let's use my contract. It definitely shows that I am prepared, that this isn't just kind of your, independent contractor mill. We're really not independent contractors. We just get these, run of the mill contracts from the prime or the business. So I think either could be an acceptable approach, but I certainly see your perspective there. Another question is, what are your thoughts on what a good IC agreement looks like? If a company has a standard subcontract template under a federal government prime contract and the IC will be supporting that contract, would you recommend using the existing template? I love this question. You were speaking my language here. So if you are a government contractor under a prime contract, independent contractors are subcontractors under almost any regulation. So you could certainly use your standard subcontract agreement for that independent contractor. It's, legally a very similar relationship under those regulations. The caveat there is that most of my clients say it's really hard to get ICs to sign that darn thing. And there are some provisions in a more corporate, larger business focused subcontract that maybe don't work as well for an individual. For example, there might be provisions you want in an independent contractor agreement, like you are not going to hire other employees unless you get approval for us first, right? Because we don't know, we want to have some quality control. We're not saying you can't do it, we just want to know first. there's some standard provisions regarding, like, by the way, you are verifying that you're not getting benefits from us, that we're all clear on what you're not getting. So there might be some things that you want to bake into that. There might be some provisions that seem very onerous to an individual who's an independent contractor. Those subcontracts can get very long. You should make sure that you have the FAR flow down clauses, because they're a subcontractor, right? And I get a lot of pushback on those FAR flow down clauses. I'm like, look, that risk is on you as the prime contractor, but you are hiring a subcontractor when you hire an independent contractor. So legally, you should have the same, very similar bells and whistles. There are some things that we can cut out, make it shorter, but it can look very similar to your regular subcontract agreements. The other thing that you might want to tinker with are the termination provisions. Larger subs tend to want guarantees that if an option is exercised, they're going to get the full freight on the next option year unless you have a termination. For independent contractors, we often recommend a simpler kind of clause where people can give notice, but it depends on who you're hiring. So I think that's a very good point and well worth talking about for a minute. All right, next slide. That is